Thank you, everybody. Thank you, and it is good to be here. I'm so glad. This is my first appearance at the ACS, and Lisa Brown called me up, and she said, Senator, I want to ask you a question. And I said, surely, any question you'd like. She said, do you believe in free speech? And I said, of course I believe in free speech. She said, well, then give one. So here I am, and I'm delighted to be here, and I want to thank all of you for the good work that you do. And it's great to see that this fifth convention is the best and biggest so far, and I know it'll even get better. The need for the ACS grows greater and greater every day. All you have to do is turn on the television, read the newspaper, and you know how much you are needed. I also want to thank, all of us who are elected officials. There's some wind beneath our wings. That's our staffs. And they do a great, great job and make us look good. And I'd like to thank three of my staff members who are here today. Preet Bharara, our Chief Counsel. Elliot Williams, another of our counsels, who is somewhere here. And Ariel Gorin, who is one of our staff members as well on the Court Subcommittee of the Judiciary Committee. Now, today I'd like to speak to you about our most recent Supreme Court appointees, Chief Justice John Roberts and Associate Justice Samuel Alito. I had the privilege to take part in their confirmation hearings. I did my best to perform my solemn constitutional duty to assess their fitness to take their seats on the High Court. I did my best to ascertain their legal philosophies and judicial ideologies with careful questioning, as did my colleagues on the Judiciary Committee. Neither of them was particularly forthright in answering questions, and I therefore could not in good conscience vote to confirm either one of them to the highest court in the land. This afternoon, I want to address three questions that arise from the experience of the Roberts and Alito confirmations. Question one, were we duped? Question two, what lessons should we draw from the process that led to the confirmation of Roberts and Alito? And question three, how should we apply those lessons to the next nomination to the High Court? Let me go to the first question, were we duped? Or were we hoodwinked? Although I did not in the end support Judge Roberts, he garnered an impressive 22 Democratic votes, and I anguished for days before ultimately voting nay. And although Judge Alito managed to win far fewer votes than Roberts, there were no serious efforts to block him, and he too was easily elevated to the High Court. So the question comes, were we too easily impressed with the charm of the nominee Roberts and the erudition of nominee Alito? Did we mistakenly vote our hopes when our fears were more than justified from the ultra-conservative records of these two men? Were senators too quick to credit these nominees' solemn salutes to modesty, stability, and incrementalism? Were we sold a bill of goods by two hyper-smart and well-coached nominees who artfully exploited a confirmation process ill-suited to lay bare their genuine judicial philosophy? Based on the record of the last Supreme Court term, sadly, the answer to each of these questions is yes. Recall the confirmation hearings and the assurances given. First, we were promised an era of gentility and consensus if the affable John Roberts were confirmed as Chief Justice. Roberts portrayed himself, to use a term we've heard before, as, quote, a uniter rather than a divider. He would be the consummate chief, we were told, because he understood the importance of respecting other justices' points of view. He would be a consensus builder. Unfortunately, that portrait bears no resemblance to the bitterly divided Supreme Court we saw last term. We saw fully a third of the court's docket decided on a 5-4 basis. We saw normally placid justices taking the unusual symbolic step of reading their dissents aloud from the bench. And we heard astonishingly harsh rhetoric by Supreme Court standards from the increasingly marginalized liberal wing of the court. One assessment from Justice Breyer overnight became the most pithy and poignant indictment of the new court's direction, particularly when compared to their assurances at the hearings. Justice Breyer stated, quote, "It is not often in the law that so few have quickly changed so much." Justice Breyer's comment leads me to my second point about the false advertising at the confirmation hearings. So few have quickly changed so much. Justice Breyer was, of course, referring to the new, quote, "dynamic duo," unquote, on the court. While politicians sometimes campaign on a platform of change, aspirants to the court wisely do the opposite, selling themselves not as agents of change, but as guardians of stability. In this regard, Justices Alito and particularly Roberts were masterful in their public statements. Both Roberts and Alito repeatedly claimed their loyalty to the principles of stare decisis and the strong gravitational pull of precedent. Even before his confirmation hearing, Judge Roberts was compulsive in his studied invocation of, quote, "judicial modesty," unquote. He unfailingly advertised himself as a judge who appreciates that his role is limited and who has the humility to respect the precedent that forms the rule of law. Roberts insisted that his analysis of cases, quote, "begins with a basic recognition of the value of precedent." Excuse me. He went on to explain, and again I quote from him, "Judges have to have the humility to recognize that they operate within a system of precedent, shaped by other judges equally striving to live up to the judicial oath. And judges have to have the modesty to be open in the decisional process to the considered views of their colleagues on the bench." He used the words humility and modesty over and over and over again. Roberts then famously likened his role to judge to that of an umpire. He said, and I quote, "Umpires don't make the rules, they apply them. They make sure everybody plays by the rules, but it is a limited role. Nobody ever went to a ball game to see the umpire. But the umpire has to play by the rules too. He has to call balls and strikes based on the strike zone developed by those who came before him. Unfortunately, if there is one thing that this term has showed us, notwithstanding protests to the contrary, it is that Chief Justice Roberts seems intent on changing the strike zone. When the team he favors is at bat, those who seek to restrict access to the courts, those who seek to roll back civil rights and liberties, he calls all balls. When the team he doesn't like is at bat, he calls all strikes. If the past Supreme Court term were a movie, it might be called The Umpire Strikes Back. Not to be outdone, Justice Alito also professed his deeply held respect for precedent. During his hearing, he testified, and again I'm quoting him, "I think the doctrine of stare decisis is a very important doctrine. It's the principle that courts in general should follow their past precedents. It's important because it limits the power of the judiciary. And it's important because it reflects the views that courts should respect the judgments and the wisdom that are embodied in prior judicial decisions." This easy rhetoric simply has not been supported by their decisions. In case after case after case, it becomes more apparent that there was little truth in advertising. In case after case, our most recently confirmed justices have appeared to jettison decisions recently authored by their immediate predecessors. Although Roberts and Alito both expressed their profound respect for stare decisis at their confirmation hearings, many of their decisions have flouted precedent. For example, in Gonzalez versus Carhart, they upheld a federal law prohibiting so-called partial birth abortion, even though just 7 years ago, the Supreme Court struck down an almost identical state law as a violation of Roe v. Wade. In the Seattle School District case, they ruled that public schools cannot consider race to achieve desegregation except under limited conditions, even though only 3 years ago the court held that colleges and universities have a compelling interest in achieving diversity and may use race as a factor in their admissions decisions. In Wisconsin Right to Life, they adopted a new legal standard that will allow for virtually unlimited advertising by corporations and unions before elections, even though only 4 years ago the court upheld a provision of the McCain-Feingold Act that prohibited advertisements funded by corporations and unions that mentioned specific candidates immediately before elections. Third, at their confirmation hearings, both Roberts and Alito presented themselves as fair as compassionate, as jurists who would treat the powerful and powerless equally before the law. Yet the decisions this term were especially cruel, advancing the traditional conservative preference for the government over criminal defendants and the interest of business over consumers and its employees. For example, in Ledbetter, they made it extremely difficult for victims of pay discrimination to sue. The court held that a claim must be brought within 180 days of the time a person's pay is set, even though it is rare that a person would know that another employee's pay in the time period and have the information needed to be able to bring the discrimination claim. In Bowles v. Russell, a particularly outrageous decision, the court ruled that a criminal defendant was barred from appealing when a federal district court mistakenly gave him 17 days rather than 14 to file his appeal. Even though the defendant followed the instructions of the district court, the court held he was barred because the trial judge made a mistake. The court's decisions reflect a seemingly inexorable instinct to unravel any precedent or torture the language of a statute or ignore the legal entities that do not conform to a traditional ultra-conservative ideology. To be sure, as one commentator put it, often rather than expressly overrule precedents with which he disagrees, Justice Roberts gives the appearance of, quote, tweaking the law, all the while performing radical surgery. Rather than explicitly overruling precedent, Justice Roberts has happened on a strategy of gutting prior opinions of all force and substance, leaving only the hollow and brittle shell to be overruled easily in the future. That's not judicial restraint. It's a shell game. This is perhaps an extension of the confirmation show. Pledge allegiance to precedent in word and in theory, but cast inconvenient precedents aside in deed and in practice. No one should be fooled. Of all people, Justice Scalia noted in his concurring opinion in Wisconsin that Roberts' parsing of language did not mask his intention to overrule precedents. Scalia was correct when he wrote that, quote, this faux judicial restraint is judicial obfuscation. That's one place many of us would agree with Justice Scalia. He was exactly on point, even though he came from the other side. I don't agree with Scalia on much, but on this point I do. There's nothing principled or restrained about overruling cases while pretending you are not. Although we have only experienced one full term with both Roberts and Alito on the Supreme Court, it appears that we were not given the most accurate picture of the nominees we confirmed. After hearing Roberts wax philosophic about judicial modesty at his confirmation hearings and then reading his calculated decisions furtively defying stare decisis, I can only conclude we were presented a misleading portrait. And so every day I feel more comfortable with my vote against Chief Justice Roberts. And every day I'm pained that I didn't do more to try and block Justice Alito. I was one who felt we ought to filibuster. But my colleagues convinced me we just didn't have the votes. 36, and we needed, of course, 41. We should have done everything we could to have blocked Alito, because his decisions will influence America for a generation. Alito shouldn't have been confirmed. We should have done our job better. As I said, many of my colleagues said we didn't have the votes. We should have done much more to persuade them to switch their positions. We needed 5 of those 9. So every year when I take stock, every Congress, I said, what is my greatest regret about something I did or didn't do? In each Congress, I spend a little time and try to figure that out. Clearly, in the last Congress, it was not being able to persuade my colleagues to filibuster Justice Alito. Now, question 2. What are the lessons learned? Let me turn to the second question. Lesson 1 is that confirmation commitments made at Senate hearings and Senate hearings themselves are often meaningless. That's true for a number of reasons, many of them obvious. First, hearings produce a lot of sound and fury, often signifying nothing. It's too easy to evade a question, it's too easy to refuse to answer, it's too easy to be coached, and it is too easy to offer an easy platitude rather than a concrete opinion. Reporters will focus, as is their wont, on the gotcha game. They will report on who yelled, who cried, who was funny, who was charming. When Alito's wife began to cry during her husband's hearing, that seemed to have more effect on the media analysis than anything else said or done on that day. Moreover, when recounting the actual content of the hearings, the media reports, unvarnished and uncritical, some of the most banal platitudes. My favorite were headlines in major, erudite, normally thoughtful papers like the New York Times and Washington Post. The Washington Post helpfully proclaimed after day 1 of the Alito hearings, Alito says we'll keep mind open. That was the headline. Seriously, late in the day, myself and others had brought out in questioning that he would not commit to keeping Roe v. Wade. That was mentioned in paragraph 27, and this was the headline. Can you imagine a nominee saying, I promise you, my mind will be closed? While platitudes are the order of the day, truth about a nominee's legal proclivities are underreported by both the press and the nominee because the process is rigged that way. Lesson 2 can be summed up in 4 words. It's the record, stupid. What do I mean by that? I mean that given the dearth of information discoverable at the hearing, the single most important measure of a nominee's judicial philosophy and likely approach on the bench is his or her concrete paper record. When Justice Alito sat on the Third Circuit, we knew from his dissents that he was usually to the right of his Republican colleagues on the bench. That was the most important indicator of how he would judge on the high court. Alternatively, when the Senate is stonewalled in obtaining information, we're unable to make a careful and reasoned judgment about whether to confirm. Similarly, when a nominee has a sparse record, he's effectively a stealth candidate. And because the hearings provide much more heat than light, we cannot make a good judgment about the fitness for the court. Even if we double the length of our hearings, testimony from the candidate cannot come close to filling the information gap created by a sparse record. Lesson 3, ideology matters. It stands to reason that a conservative lawyer who's represented the most conservative administrations and taken the most conservative positions as a lawyer is likely to be a very conservative jurist. Senators have an obligation to scrutinize the character and philosophies of judicial nominees. Nominees have an obligation to cooperate. This is especially when a nominee's ideology, judicial philosophy, and constitutional views are central consideration in the President's decision to nominate. There's an inherent logic in preventing the Senate from considering the one factor, ideology, that is the central to the President's own nomination decision. It is best for the Senate and the country when this scrutiny and debate occurs in an open and rational way. It is no longer reasonable or sensible or smart to hypothesize that such a person will grow on the bench and become something that she never was because it's our hope or wish. At every confirmation hearing, we're treated to tirades about David Souter and Earl Warren being more liberal than expected. We're told, you never know how someone will turn out. These days are over. As people have come to understand the central importance of the court, the need not to take chances, particularly when an administration that nominates says they are nominating somebody only with a particular ideology and tout it to their base. That leads me to lesson 4. Take the president at his word. When a president says he wants to nominate justices in the mold of Scalia and Thomas, believe him. Don't be fooled by occasional chink in a nominee's conservative armor that he once worked for a pro bono for a gay rights group, for example, or that he does not subscribe 100% to Justice Scalia's blanket refusal to consider legislative history in interpreting statutes. The burden of proof lies with the nominee to prove that he is something other than what the president chose for him. The burden always lies with the nominee to show that he or she is within the mainstream. And that burden cannot be met, as we've seen, by mouthing pleasant platitudes about modesty and stability at a confirmation hearing. Ultimately, the overarching lesson of Roberts and Alito could be summed up with the familiar old phrase, fool me once, shame on you. Fool me twice, shame on me. So how do we apply these lessons? That's the third and final question. How do we apply the lessons we learned from Roberts and Alito hearings to the next nominee, especially if, God forbid, there's another vacancy under this president? We now have the most conservative Supreme Court in memory. As everyone knows, the justices who are actuarially speaking most likely to step down next are the liberal ones. The court is, interestingly, at odds with the country. As the court grows more conservative, the rest of the nation is in the midst of a pendulum swing in the progressive direction. Unless we're vigilant in our efforts to moderate the court, in the next 2 decades, that institution will stand in the way of a much-needed and long-overdue swing back to moderation. I'm not a scholar or a practitioner, but a senator. As such, I'm vested by the Constitution with the responsibility to provide advice and consent on the President's judicial nominees. So based on my experiences of the last 2 years and my reading of the last term's cases, let me share with you how I intend to apply the lessons learned and try to persuade my colleagues to do the same. First, because of the limited usefulness of the hearings, when in the future we're presented with a nominee with a sparse written record, a senator might very well be justified in voting against the nominee on this basis alone. One should not have to engage in conjecture about a nominee's way of thinking and method of reasoning. This is not the lotto. As we have seen, a stealth nominee with a sparse record has scarce incentive to provide meaningful answers to the questions about judicial philosophy and constitutional interpretation. Second, for the rest of this president's term, and if there is another Republican elected with the same selection criteria, let me say this: we should reverse the presumption of confirmation. The Supreme Court is dangerously out of balance. We cannot afford to see Justice Stevens replaced by another Roberts or Justice Ginsburg by another Alito. Given the track record of this president and the experience of obfuscation at hearings, with respect to the Supreme Court at least, I will recommend to my colleagues that we should not confirm any Bush nominee to the Supreme Court except in extraordinary circumstances. They must prove by actions, not words, that they are in the mainstream, rather than we have to prove that they are not. So in conclusion, In the end, these three questions provide the foundation for thinking about how we ensure that our court reflects what America wants, rather than a diminishing clique of conservative ideology, rather than what a diminishing clique of conservative ideologues wish for. There's no doubt we were hoodwinked. Let me remind you of one particular striking passage from Justice Roberts' confirmation hearings. Senator Graham asked him, quote, "The idea of a dramatic departure under your watch from the Rehnquist era is probably not going to happen. Is that true?" Roberts responded, "Given my view of the role of a judge, which focuses on appropriate modesty and humility, the notion of dramatic departures is not one that I would hold out much hope for." Of course, now, only a short while later, we have a better understanding. There is no way to say it better than Justice Breyer. It bears repeating. It is not often, he said, in the law that so few have so quickly changed so much. And this somber judgment, after just one full term of Roberts and Alito, this is just a prologue, considering the constitutional harm and dramatic departures that are in store if those few are joined by one more ideological ally. We have to, in my judgment, stick by the precepts that I've elaborated. I will do everything in my power to prevent one more ideological ally from joining Roberts and Alito on the court. Thank you.